Okay, good afternoon, Colorado. This is the Colorado Oil and Gas Conservation Commission. It is Friday, December 9th, and we have a general session posted for this afternoon. We will start by taking a roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Bogue. Here. Commissioner Cross.
Present.
Commissioner McGowan. Here. Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Great. Great to see everybody. And great to see everybody on a Friday afternoon. We've had a long week, but we have an important docket before us. We have one matter on the agenda this afternoon. It is docket number 2208-00233. It is a petition for rulemaking to adopt rules to evaluate and address cumulative air impacts. It is filed by Wild Earth Guardians and several other associated groups. And we are here to consider that this afternoon. I wanted to provide some background on this filing and the process that the commission has undertaken to date. First, want to sort of talk generally about petitions to commission. So our rules and regulations establish that any person may petition an agency to conduct a rulemaking, and the commission needs to make a decision on the petition at some point. But the Administrative Procedures Act and our commission rules do not set any timeline or process relative to that decision making as to what to do with a petition. So how to make a decision and when to make a decision are left completely to the discretion of this 7-member board. We created this process to allow anyone to provide their, since we received the petition, and it was received on August 30th, we are taking it up now. I want to talk a little bit about the things that have happened between receipt of commission petition and where we are today. On October 13th, we posted on the COGCC homepage notice that the commission was accepting written comments on the petition. The announcement included the hearing officer's order governing this hearing today. The hearing order allotted the Wild Earth Guardian and other group 10 minutes today to present its petition to the commission. The hearing order also gave the public until December 2nd to provide public comments. Approximately 7 weeks was allocated for public comment submittal. We also would note that we heard from stakeholders that an easier system to submit public comments was necessary. People were having trouble providing written comments. So Hearings Manager Larson put in place an electronic form that didn't require the public to register for an e-filing account. In other words, we made it easier for folks to provide written public comment. All of the public comments that we received are part of the docket, and there is a link to be able to go to that docket and see those public comments. I would note that we received 124 written comments from either individuals, companies, local governments, environmental groups, coalitions, etc. So with that, we will proceed on our agenda, and the next part of this docket is for a presentation from the petitioner. So if we could elevate Ms. Merlin to the panel, I believe she is going to make the presentation. Good afternoon.
Hi, sorry, I think we're still missing one person. Heidi Leithwood was going to join us.
Okay.
And Ms. Merlin, could Heidi raise her hand? I'm not finding her in the participants. Oh, here we go. I'm sorry, if Ms. Leith could raise her hand one more time. It seemed to have gone, there we are. Okay, thank you. She'll be coming in.
Okay.
Are you ready for me to go ahead and share my screen?
Okay, yeah, Heidi, sorry, I didn't see there. Sure, you can start screen sharing. Actually, before we begin, commissioners, I've run through this presentation a lot of times. I can speed read it to you in 10 minutes.
I'll just go ahead and answer that question from the chair's perspective. I'd rather hear it in a fashion that allows us to understand what it is you're saying. And so, we want you to be timely, but I'm not going to hold you firmly to the 10 minutes.
Thank you. Yeah, it's just a lot to cover, so I'll do my best. All right, so Heidi, you can start the screen sharing whenever you're ready. All right. Good afternoon, commissioners. My name is Catherine Merlin, staff attorney with Wild Earth Guardians. I'm representing these 6 groups here in support of our petition for rulemaking to evaluate and address cumulative impacts. And I have with me Heidi Leithwood from 350 Colorado. Commissioners, our groups are here with an invitation to collaborate. You are the state experts in oil and gas regulation. Rulemaking is an area in which you enjoy some of your broadest discretion. That doesn't change when it's initiated by a petition. Cumulative impacts of oil and gas development are attracting a lot of scrutiny from lawmakers, other state agencies, the US EPA, and the public. Our severe ozone non-attainment, climate change, pollution, and disproportionately impacted communities are impacts that are showing too little progress to come near achieving our legislatively mandated goals of healthy air, climate stability, and equity. Pressure is growing for significant steps to address them. If this commission declines to conduct a rulemaking, rules will be made elsewhere by other people. These issues will not wait any longer for more data collection while the impacts continue to accumulate. I understand as well as anyone the considerable time and resources required in rulemaking, but this public process, which allows all stakeholders to come to the table, to present facts and arguments, to use the best available science, to hold robust debate, to arrive at practical solutions, balancing the interests of all affected parties, is the Colorado way. In its final statement of basis and purpose for the mission change rulemaking, this commission repeatedly acknowledged the need for this rulemaking, saying that it fully intended to conduct more rulemaking to address cumulative impacts once it had more data. We are now 3.5 years past SB 19-181, which mandated the adoption of rules to address cumulative impacts to protect public health, safety, welfare, and the environment, and nearly 2 years since mission change. According to our data, almost 5,000 new wells have been approved in that time. We must move past data collection. Colorado has not come close to getting in line with federal health standards for air quality. We are not close to reaching our statewide GHG emissions reductions targets. And the commission has continued to approve dozens of new projects, often very large ones, in and around communities which are already overburdened with current and historical sources of pollution. The cumulative impacts of oil and gas production, including ozone, climate change, and disproportionate impacts, are at crisis levels. The first cumulative impact that we must address is ozone. This is data from the Regional Air Quality Commission. Again, both the RAC and CDPHE acknowledge that oil and gas is the #1 in-state man-made cause of ozone. It is also by far the largest source that we can significantly control. It is key to reducing the number of high ozone days. If the commission is going to continue permitting significant new sources of ozone, the simplest and most effective step to combat ozone is to shift the timing of emissions. Ozone non-attainment is becoming extremely costly. It will continue to inflict expensive and onerous requirements until we demonstrate attainment. This cannot be achieved by reclassifying emissions and other accounting methods. The Clean Air Act requires that attainment be demonstrated with air pollution monitoring. The commission is approving thousands of tons of new ozone-forming pollution and tens of millions of miles of diesel truck traffic annually. These projects may last 20 years or more, and each year of approval adds to emissions approved all the years before, which all add to ozone from sources which are largely or entirely out of the state's control. Our proposed rules shift the timing of the highest emitting processes away from non-attainment season, which is likely to result in actual measurable air quality improvements without banning oil and gas production. They also limit a smaller set of high emitting activities that have timing flexibility during atmospheric inversions. We need to talk about the COGCC's cumulative impact or CIDR data quality. This data is so important. The operator reported data for OGDP and CAP applications, although quantified, does not seem to be standardized and does not create enforceable limits even within a range. Operators have almost no incentive to ensure accuracy. And if these projections are later shown to be incorrect, operators are not required to go back to update the CIDR database. I reviewed the OGDPs approved in 2022. In many of them, entire categories of emissions were blank. I have two examples. This first OGDP approves 30 new horizontal wells in the non-attainment area. The operator reported that their 44 separators will generate 0 emissions. It also reported 0 emissions from its 4 enclosed combustion devices and 0 flowback or completions emissions, even though completion and flowback are well known to be among the most polluting phases of development. Let's compare the first OGDP with this one, 8 horizontal wells about 30 miles away. This one only has 8 separators, yet this operator reports that those separators will emit more than 35 tons of VOCs annually, making it a new major source of ozone. This operator also reports, though, 0 emissions from its combustion control devices and no emissions from well maintenance activities or braided heads. These numbers don't make sense. Emissions from the same activity at similar facilities differ by orders of magnitude. But if these numbers are accurate, why are you approving some operators to emit 100 or 1,000 times more pollution than another operator does for the same activity at a similar facility? The Commission is required to avoid adverse impacts if possible and minimize and mitigate impacts that can't be avoided. Therefore, it is essential that the impacts data at the application stage is as accurate as it can be. Our proposed rule on data accuracy requires operators to update and correct their cumulative impacts data and incentivizes operators to work harder at ensuring accuracy up front by allowing the Commission to revoke approvals where cumulative impacts of the project were understated. Accurate CIDR data is crucial for informed decision-making across the state. The data is used by the Commission, its staff, by the public, by other agencies, and by the legislature. The database is made up entirely of self-reported projections. It's irresponsible to allow a crucial state database to be populated by industry's self-reported projections that have no substantial incentive towards accuracy, no penalty for inaccuracy, and aren't later verified by experience, and frankly, don't pass the smell test. Climate change is perhaps the ultimate cumulative impact. This Commission has overlapping mandates to protect public health, safety, and welfare in the environment, to evaluate and address cumulative impacts, to avoid adverse impacts, and to do its part to help the state meet emissions reductions targets. The Polis administration gave CIDR a key role in evaluating climate progress to identify recommendations of additional steps that may be needed to improve the implementation of regulatory requirements. APCD's August 2022 progress report to AQCC shows that our state is off track and expected to exceed legal 2025 GHG targets by between 11.4 and 14.4 million metric tons. For comparison, that's almost exactly the 12.2 million metric tons of reductions that were expected from all the proposed oil and gas sector rulemakings at both AQCC and COGCC. But your current rules do not allow you to delay, deny, or limit permitting in order to help meet these greenhouse gas targets. The Commission is approving a huge percentage of the state's new greenhouse gas emissions, as also the body with the most discretion to deny permits on the basis of health, safety, welfare, and the environment. Therefore, we suggest that this Commission can use its outsized opportunity to do more by halting new permits when greenhouse gas reduction goals are not being met. It's not waste to deny or delay new production to meet our desperately needed climate goals. The legislature rewrote Section 60 to allow protection of people and the environment over the previous mandate to extract every molecule of carbon as fast as possible. Additionally, our groups request that this Commission consider no new permitting in areas where warming has already exceeded 1.5 degrees Celsius. Appendix C shows that 24 of our 64 counties have already hit this target. Many of them are large oil and gas producers. Many are not. Ouray County and San Miguel County are down in our breathtaking San Juan Mountains, including Mount Sneffels, which is depicted on our driver's licenses. They've always looked a lot like the image on the left. They're not big oil and gas producers, yet they have some of the highest rates of warming, and every year they look more like the image on the right, with declining snowpack, dying pines, drying forest soil, bigger fires, increasing pests and non-native species, the loss of native species. It is truly heartbreaking for people who love Colorado. In a just world, every county would cause warming only to itself and be able to decide how much warming it will tolerate in exchange for oil revenue. The science is admittedly inconclusive about the degree to which local emissions cause or contribute to local warming, but this really gets the question backwards. Every one of us has a duty and a responsibility to avoid harming our neighbors. Areas that are not large producers will not be adversely affected by this rule. On the other hand, high producing areas that are already experiencing rapid local warming have an oversized obligation to their own populations as well as to the rest of us. The last topic I'd like to address is equity. I think we can all acknowledge that Colorado was colonized, appropriated, stolen by European settlers' westward expansion. The colonial project was explicitly genocidal, both physically and culturally. Our laws and legal system were developed in this context with the aim of maximizing growth and economic exploitation of natural resources. We built highways over houses. We put oil wells in playgrounds. And the people building the highways and the oil wells weren't the ones who lived in the houses. Their children played in playgrounds far away. It is wrong, and it has always been wrong. In recent years, there's been an effort by our state government to stop doing it. Truth and reconciliation needs more time and a lot more effort. We've started, but we need to do so much more. The DJ Basin is home to millions of people. It is one of the most densely populated areas of our state. It's also the area with the most oil and gas wells, both existing and proposed. I do need to correct the record regarding figure 1. So I don't know how old figure 1 is. I pulled it from my files. It might be from as long ago as 2014. So we have another slide. This is what it looks like now. 8 years isn't a very long time to go from that to that. I'll also point out that statewide map tends to flatten out just how many more wells there are in the North Front Range than anywhere else. So we've created slides comparing the location of new and proposed oil and gas facilities with the state's EnviroScreen map. The data was a little hard to illustrate because it's all in different places. We're not graphic designers. But here's a map showing your OGDPs, caps, and pending applications in the DJ Basin. We tried to illustrate around some of the larger projects in pink, particularly in and around DICs. Now you see the overlap with EnviroScreen, which is used to map disproportionately impacted communities as defined by state law. You see from all the areas of overlap that the existing rules seem to have been unsuccessful at improving equity. We also wanted to put the large project illustration over your map that pinpoints the individual locations, wells, and bores that have been approved, and how these all cumulatively lie over the DIC map. I know it's a lot to take in visually, but what we want to point out is that while some areas have a lot of overlapping colors and other areas are just white, and I'm sorry for the visual pun, but for the fact is that oil and gas development is still being approved disproportionately in communities where the state is actively trying to increase equity, and that's what these maps show. Commissioners, evaluating and addressing cumulative impacts is of vital importance to the state. Oil and gas development is the single largest in-state contributor to our ozone non-attainment, and the one that the state has the most direct control over, much more than what cars people can drive, when people drive, mow their lawns, or any of the other individual actions that Coloradans have been asked to change, but that even in the aggregate are a much smaller source. What is reasonable in the face of the climate crisis? Some of our agricultural counties are at 2.4 degrees Celsius of warming already. Every gardener and farmer here knows the truth. This is a matter of life or death, and even a complete ban would not be unreasonable. Your authority to craft rules might actually be broader than your authority to avoid crafting rules, given the enormous weight of evidence that there are serious and acknowledged gaps in this commission's rules addressing cumulative impacts. the grave harms to public health, safety, welfare, and the environment, particularly in disproportionate impacted communities, and the multiple overlapping statutory mandates to address these kinds of harms. According to the data that we could find, you've approved nearly 5,000 wells since 2019. The idea that we need more data before we can do anything is just not going to fly anymore. And I want to wrap up this presentation by saying again, this proposal for rulemaking is a good faith invitation that you all should eagerly accept. This crisis is happening now, and folks have been patient and swallowed these impacts for years, waiting for something to meaningfully change. Reading through the comments submitted to you, even opponents aren't mostly denying there's a problem. Accepting this petition and moving to a rulemaking gives you the most control over the outcome, the best opportunity to use your experience to craft rules that balance the interests of stakeholders, ensure that everyone feels heard and respected, and emerge with rules that you have already acknowledged both the need for and the commitment to develop. Thank you.
Thank you. If you want to stop the screen share, then we'll be able to see everybody a little bit better. Okay. Thank you for that presentation. Thank you for the filing earlier this year. At this time, commissioners, the way we've set this up is we have an opportunity, if anyone has questions for the panel, that would be the time now. Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Ms. Merlin, for being here today and sharing your presentation. I'll start off by asking if you've read any of the other commenter submissions and the request for some of them to actually turn this into some sort of a work group or stakeholder process that makes recommendations around how to improve our cumulative impact analysis, and your thoughts about that.
Yeah, so I will confess that I have not read all of the stakeholder comments. There were a lot of them, and I was busy working on my presentation to try to get it down into a very small amount of time. I agree, this is a huge topic, and, like I couldn't even get into it in 10 minutes, 10 hours, we might be able to get into it. I think that that's what a rulemaking is. I would worry about the opportunity for a working group to simply be a way of delaying it, but I think it's entirely within your agency's discretion, both to determine whether to progress with this rulemaking or to not and do something else instead. The states had a lot of working groups, and I don't know if we've seen enough progress. I would recommend that we move to rulemaking, but we wanted to have some pre-rulemaking engagement with stakeholders. I would be supportive of that. Thanks.
There were some things in your request for rulemaking and some things that you brought up that I think I'm trying to figure out I'll say whose sandbox they belong in. And so some of the things that you're asking for, like I would see perhaps as SIP strategies, which is a RAC function, Regional Air Quality Commission function, not a COGCC function, or potentially like not doing something during the non-attainment season, which would also be, in my mind, a recommendation from the RAC, and giving the COGCC strategies or some guardrails with which to work from. Arguably, I think the COGC is not the air quality expert, CDPHE is, and the RAC is the one that helps when we're in non-attainment areas set strategies and try to measure where various emissions are coming from. So I'm wondering if you could speak a little bit to the roles of the various agencies and why some of your requests are coming to us and not, for example, to CDPHE or to the RAC.
Yeah, thank you for that, Commissioner McGowan. I mean, I think what I would say is that this commission has multiple statutory mandates that are not abrogated by the mandates that belong to other agencies. This commission, I think, has a unique position in that SB 19181 gave you the explicit, I think, authority to deny permitting in order to protect public health, safety, and welfare. You also have a great deal of discretion to shift the timing of permits and shift the timing of operations to protect public health, safety, and welfare. Other agencies are constrained by other laws that they have to follow. You know, I will confess, I'm not as familiar with, you know, AQCC as I am with COGCC. You know, do they have the authority to deny something if it, you know, checks all the boxes, but is adding a heck of a ton of ozone? You know, I can't speak to that. What I can speak to is that this agency has multiple statutory mandates to protect public health, safety, and welfare of the environment, to address cumulative impacts. I mean, if ozone isn't a cumulative impact of oil and gas production, when oil and gas production is the #1 contributor, I don't know what a cumulative impact would even be, which actually brings us to the point that we did recommend including a definition of cumulative impacts, which, although it's in your statutory mandate, it doesn't have a definition in your rules. So we think that would be an appropriate addition. You know,
Thanks for that. I think from this commissioner's perspective, right, CDPHE is the owner of air emissions in the state, and they see the whole puzzle. We are one piece of the puzzle. We're the oil and gas puzzle. There's a transportation part, there's a stationary sources, there's mobile sources. And I think I'm concerned if we don't do things in collaboration with sister agencies who are tasked with some of these similar kinds of things that you're asking us to consider in a hearing, we might have redundancies or actually things in conflict with one another. And so I'm wondering also, I'm just kind of thinking that maybe others need to have a voice or a seat at the table as we talk about what we need to do for next steps for our cumulative impacts analysis, and what things are already being done by other agencies, what things we have the resources and or expertise to tackle. I mean, this says evaluate and address. That means we actually have to be able to address whatever it is that we put in our analysis or require as part of cumulative impacts. These are my thoughts. These are my thoughts.
I appreciate that. I appreciate
I'm also wondering if you've seen the recommendations from the Environmental Justice Task Force and some of the things that I think that you're asking for in here related to disproportionately impacted communities, how they should be addressed, are in those recommendations and going to the legislature for review and adoption for if they are going to adopt or not, and potentially could we be putting the cart before the horse if we don't see what the legislature does with those recommendations.
Okay, thank you. Sorry, that was a lot of things. I'll try to, I don't have great working memories. I'm going to try to make sure I address everything. Wild Earth Guardians, and I believe all of the groups that are involved in this petition, have been saying for years that this commission needs to work on a much more deeply collaborative basis with particularly the Air Permitting Control Division, you know, as well as the AQCC. So we have no objection to that. We definitely think that collaboration is warranted and appropriate. Sorry, like responding to one, I got to kind of erase all the others.
Yeah, have you seen the recommendations from the Environmental Justice Task Force?
You know, I wasn't a part of that task force. I did hear quite a bit about it in some of the meetings that I've been to, but no, I haven't read all of them, you know.
So I think there's some similar themes, and they're really good questions. I'm just trying to figure out how we put all these pieces together and make sure that we're working collaboratively.
Right. So
I've seen the recommendations.
Heidi, go ahead.
And, you know, I'm not studied up on it right at this moment, but
there were a lot.
What's coming to mind is the fact that they do recommend that every single agency use disproportionately impacts analysis to look at these kinds of issues and make their decisions accordingly in order to protect disproportionately impacted communities and reduce harms to them.
Yes, but aren't they also making recommendations about what that analysis could or should look like, and whether or not it should be centralized or done individually by different agencies?
Yeah, I think that's still a little bit up in the air, but there would be nothing to prevent rules that had some flexibility to allow for how that plays out. And if a rulemaking process is put into place right now, it takes a while. And so likely we would know more during that whole stakeholder process of the rulemaking.
And I think it's a little, I think it's a little bit wrong to say, hey, the state has acknowledged that there are serious problems, so let's not do anything about those problems. Let's wait, for some 6 months, a year, more years. I mean, how much more do we need? We know there are problems. We know we need to act. Let's all get together. Let's bring the parties together. Let's have engagement. One other thing that I did want to address, as far as the ability to control the timing of some of these things, you do have wildlife rules which control the timing of a lot of oil and gas operations to protect wildlife. I don't see why you couldn't adopt the same rules to protect people.
Yes, but we look to CPW to tell us whether or not there should be timing restrictions.
Yeah,
And
and
so
actually, so
for
these
timing
rules,
restrictions around air emissions, I would look to CDPHE to see what their recommendation would be to the commission, I guess is my argument.
totally. And actually, the statute says that you will do rulemaking in collaboration with CDPHE. So that's
They're
actually
a
part of your.
consult, and they already are a part of that process. I'm not trying to get into a tit for tat with you. I'm pointing out some things that I am trying to figure out how to weave into this request that you've given the commission and understand the role of sister agencies, the role of other stakeholders, the role of recommendations that have been put forth to the legislature, and kind of how all these pieces will fit together. So I think you bring up very good questions in your request for a rulemaking. They're questions that the commissioners have been asking of themselves, of operators. They're questions that we've been asking with our sister agencies. I'm just not sure where we're at exactly. And I'm trying to figure out, making sure that there are other voices allowed at the table if we were to head into a rulemaking. So I think that Ms. Oath had her hand up, and I know that Ms. Leithwood has her hand up as well.
If I could just address the fact that Renee Millard-Chacon might be in the audience, and she was on the EJ task force, and she's one of the co-petitioner, her group is one of the co-petitioners. So just wanted to find out if she's in the audience and if anyone wants to address any questions about the EJ task force.
Let's hear from Commissioner Oath at this time.
Yeah, thank you. I did raise my hand because of this conversation around the Environmental Justice Action Task Force. I actually was a member of the Environmental Justice Action Task Force along with Ms. Millard-Chacon. It was a very robust process, right? I mean, we had 6 full Environmental Justice Task Force meetings over the course of the past year. Most of those ran 10, 12 hours, were multiple days. And on top of that, we had 5 subcommittees that met. We specifically had a subcommittee that I sat on having to do with how to deal with this question about cumulative impacts. I do feel like, Commissioner McGowan, I think you hit it spot on, and I felt like the petitioners weren't totally representing what the findings or the recommendations were about the task force. I don't have a question for the petitioners, but more comments. So I probably can reserve kind of my characterization of what those recommendations are and how it would potentially fit into, my thoughts on this petition and some potential paths forward for our deliberation discussion.
And I just want to say one thing about, our petition does cover a wide variety of topics. We acknowledge that there was a lot we left out because we didn't want to get into every single possible cumulative impact of oil and gas. We thought that would overburden the process. We focused specifically on air quality and air impacts. There's a lot in here. And, if you feel that rulemaking is inappropriate on one topic, proceed to rulemaking on some of the other issues. That data quality stuff, that's hard to argue with. And that's not from just proposed OGDPs. Those are from approved OGDPs. That's already been through the commission's process where, operators are telling you that flowback is going to create 0 emissions. That needs some work. Like, I think we've identified some really crucial problems here. I don't think any of us would argue against stakeholder engagement, even, working with other agencies, working with the EJ task force, any legislators that wanted to join this process, of course, please do so. But I think what we've seen a lot is a promise to do something in the future. We've seen that, and the things that have been promised to happen haven't happened. And I think this crisis has grown a lot. As we mentioned, the number of new wells that have been approved. This commission has a mandate to address cumulative impacts, and we've identified a lot of cumulative impacts that need to be addressed. We think this rulemaking is necessary. It's mandated. You've said that you were going to do it. We think it's appropriate for you to start engaging in this process.
Thank you. Further questions from commissioners for the panel? Commissioner Messner.
Thank you, Mr. Chair. Ms. Merlin, I wonder if you would talk a little bit about how the process occurred that developed the rules that you're proposing, the level of diversity and diverse voices that were informed in the development, or that were utilized in informing the development of those proposed rules, and what were some of the different voices that may or ideas that maybe didn't make it into your draft proposed rules?
So one group that did contribute to this petition, although wasn't formally a co-signer, Natasha Leger's organization, I believe it's Citizens for a Healthy Community, they were heavily engaged in the development of the proposed rules around local warming impacts. And also there were other West Slope voices about our proposed ozone rules. They pointed out, prior to their engagement, our rules had focused entirely on the non-attainment area, where they pointed out that the West Slope does deal with, I think that was Leslie Robinson. The West Slope has ozone problems as well, but seem to be more closely related to atmospheric inversion conditions, which is why we added more rules about that. Some of the things that we left out, we had a request to include indoor air quality. We had a request to include water consumption, consumptive uses of water, and the amount of water that's going into fracking wells and the amount of water that's coming back out. Those are really the major things that we included or didn't include.
Did you include any voices in your deliberations or thoughts in developing these rules that maybe were voices that didn't agree with you?
So have I done a robust stakeholder engagement with industry, for example? No.
Any voices that don't agree with you in the development of the draft rules, because that's essentially what you're proposing here in this petition, is a set of draft rules to be used in rulemaking.
Sure. No one that I spoke to disagreed with me to my face, but there were people who didn't, I don't know. I don't know if everybody agreed with everything I suggested. I think that actually, what I mainly got was suggestions for improving it, for strengthening it, and for expanding it. People were asking for a lot of other impacts to be considered that they felt extremely concerned by. Again, we limited it to air quality because it is such a huge topic. It is such a pressing topic. Yeah.
So in Rule 529D, which is the development of the proposed rules for rulemaking, it indicates that, prior to the notice of a proposed rulemaking, the commission or director will establish a representative group of participants with an interest in the subject of rules. The commission or director may also use other means to gather information, including but not limited to public forums, investigation, commission staff, formation of rulemaking teams, consultation with a number of different agencies. One of the steps here is that you've done in your petition is actually draft a set of rules that you're proposing to utilize in a rulemaking without the benefit of a robust stakeholder process in developing those rules. And so
I understand the criticism.
understand.
I think. Yeah, I can understand that. You know, it's unfortunate, but when citizen groups come together to put forward a petition for rulemaking, it does require those groups to put forward concrete rules, not just a sort of, here's the problem, we'd like you to do something about it. It requires that we put together specific and concrete rules. And I struggled with that. That is, you know, that is not my specialty, crafting regulatory language. I am much better at, you know, picking it apart. And so I did, you know, we did reach out quite extensively to groups that we felt had an interest in this. And we did end up having, you know, a group of people coming together to help improve these rules, both who joined the rulemaking, who didn't join the rulemaking. At least one group on the eve of submission wanted to join, but I was like literally pressing send. You know, yes, there are different requirements when the commission is the one initiating a rulemaking versus when citizen groups are initiating a petition.
And I'm not suggesting that it was a requirement of you. I'm just asking about the diversity of input that you received in development of this, of your proposed rules that you're suggesting that we utilize as a draft in a rulemaking. So
Sure.
that was the question. So I appreciate the answers, and Mr. Chair, that's the only question I had.
Great, thank you. Ms. Merlin, you know, Ms. Merlin, along the same lines, one concern I have, well, I think you agree, and I think you answered Commissioner McGowan, that if we were to do a stakeholder working group, and if we commit to doing it, like, this is not a delay tactic, but like if we were to, you know, commit to getting something started in, you know, next month, and spend some time hearing from the diverse voices. I mean, your petition for rulemaking generated 124 different groups that have an interest in this topic. I applaud you for filing the petition. But I'm also inclined to think that we should take your effort and pivot to have the commission establish that stakeholder work group so that we can explore those 124, and there's probably more other perspectives, and then return back to commission where we can like look at what people are thinking, and then, you know, maybe by, you know, and again, I'm not, this is just me talking, but I'm not trying to delay anything. I'm just saying, let's take your efforts and let's use that as the incentive to really dig into this. I agree. Now's the time. And I appreciate the point. It's been 2 years of data gathering. We should start to evaluate that and do the addressing point, right? But I do think that we'll be better served. Everyone will be better served if we were to initiate a stakeholder group, not based upon the good work you've put together, but with kind of a clean slate, so that we don't have, so if we grant the petition and start a rulemaking, the concern I've got is that the rulemaking's baseline is the efforts that you've put forward, and that legitimately discounts other efforts that folks may have. And so what I would like to do is to move forward with the stakeholder work group, you know, spend some quality time with that, hear from all the various viewpoints, including yours. And I'm not discounting yours at all. And then the commission, we're the ones that, you know, determine, okay, what do we want to see in the straw dog after we've heard from everybody? And then we would initiate the rulemaking, and you and your groups would absolutely be a critical component to that. Do you have any reaction to that pathway forward?
I don't know whether, okay, a couple things. We saw during the financial assurances rulemaking enormous changes from the straw dog draft to the final draft. I mean, they were worlds apart. So I don't think that this is, you know, we're not setting a baseline. I think that there is, yes, we have said, you know, the issues that we want to address are ozone, climate, equity. and data quality, which, by the way, I think one of these things is a little bit different than the others. And you know, that data quality, your next CIDR report is coming out in February. And you know, that seems to be, we're making decisions today based on information that we know is wrong. So I don't want to say any of those other things are not totally urgent. They are. I honestly, you know, I'm not in charge of what everyone else is going to do. You know, whether every other group is going to see this as a delay tactic and be up in arms and, you know, resolve to do something. I don't know, you know.
I'm asking you. I mean,
Yeah. I think I would be somewhat disappointed, but of course, you know, that is your prerogative. We would engage in the stakeholder process.
okay, thank you.
We feel like, you know, what we've put together is good work based on, you know, to present the factual issues.
And I'm not discounting that. I'm just saying that that is yet one vision, one approach. And we've got a lot of interest in getting this right. And so I prefer to start with a working group that's looking at kind of, you know, without anything on the table to begin with, talk to us, issue identify, provide perspective. And I want to hear from everybody. And again, I really hope you understand, I'm not discounting this work. It'll be an important part of any working group if that's where we end up being. And I'm also honestly not saying this to sort of indicate delay tactic. In fact, I'm thanking you for bringing this back to our attention. I think we would have probably tried to go there anyway after we get this next report, which is in February. But anyway, thank you for letting me ask those questions. I appreciate it. Further questions from commissioners? Commissioner Cross?
Thank you, Mr. Chair, and thank you for the presentation today. I do appreciate you putting the significant amount of time and effort to work with additional groups to bring this forward. I think, and I'll preface this as this is more of a statement than a question, but I think as one of the newer commissioners on here, on this commission, I have appreciated the difficulties in some of what we've been doing to gather the CIDR information. With this being passed and becoming effective in 2020 and the issues with COVID, I mean, one of the things that Director Murphy talked about to some extent was the low number of OGDPs that were passed at first. And so when we tried to have CIDR come through, there wasn't a lot of information that we had. And so part of what we're gathering now is that we are getting more information through CIDR. That said, I do appreciate and understand stakeholders' frustration with the amount of time that this is taking. And I would like to reiterate that I do think that we've been making some good efforts to work and not just evaluate, but also address cumulative impacts. When you listen into a lot of our hearings, you oftentimes hear, that's good, that meets rules, what else can we do? You know, let's look at this in a comprehensive area. What are you going to be plugging in abandoning wells? Are you going to be decommissioning facilities to, for example, we did a large cap the last few days, and in the end, they're actually reducing the number of facilities near RVUs. They're actually reducing the amount of VOCs and HAPs and NOx per year based off of the legacy wells and facilities that are being decommissioned and plugged in and abandoned. And so I do think we're making some good steps with that, but I also do understand that we do need to have more than what's specifically in our rules. I believe it's 420, I believe you even said in your petition, 423, 24, 425, 426. There's some specific rules about addressing cumulative impacts related to things like dust and odor and noise and light. And so I do agree that there does need to be more of a focus on cumulative impacts. But I do agree with the sentiments of my fellow commissioners that have said this before. I think I would appreciate getting a working group together to try and talk about this, to get a broader stakeholder view and how we can move this forward, talk about additional issues such as water, talk about additional issues beyond just air impacts and some of those, and really kind of drill down into, as a state and across all stakeholders, how can we look at cumulative impacts and improve upon what we've already been doing post 181. But again, not to editorialize too much, but I think generally I would probably be in favor of going with the stakeholder meeting and trying to work forward, building on what you've brought to us already.
Further questions? Commissioner Ackerman?
Thank you, Mr. Chair. I appreciate it. I have a number of comments, but I will probably just hang on to those until we deliberate. But I do have a question of Ms. Merlin, and Ms. Merlin, thanks so much for your presentation. Very well done, and good, thorough petition work as well. Appreciate that very much. I just wanted to address one issue, and I saw this a lot in the public comments as well, and so it's a little bit of a point of clarification as well. So we are talking about certainly addressing cumulative impacts with this petition, with this potential rulemaking. There were a lot of comments in public comments and some allusions in your presentation today about the commission not making any progress and the frustration with that. I did just want to point out that there has been a lot of great work done by this commission and by the people of the state of Colorado between Senate Bill 181 and today on numerous and a variety of issues. And I'm being a little braggy here because I wasn't on the commission at that point. And so I can't take any of the credit, but I do appreciate the great work that's been done by many, many people between the passage of Senate Bill 181 and now. That said, we have a lot more work to do, and this is a very, very important issue that, as Ms. Merlin pointed out, we have committed to address and have begun to address through the gathering of baseline data. And I do think that it's timely and appropriate. I was just going to ask Ms. Merlin if your group participated in some of our previous rulemakings, and if you have any counsel for us associated with your participation in previous rulemakings with regard to future rulemakings. I know that's a bit of a broad question, but I believe that you had some good influence on our previous rulemakings as well.
Well, thank you. Yeah, I was involved with most of them. There were a few post 181 that I was not involved in the flow lines rulemaking. Can't remember. I think I've been involved in, I was involved in mission change, financial assurances, the 300 to 600 rulemaking. I might be leaving one out. Yeah, I've been involved in quite a few rulemakings, and it is, Jeff is laughing at me. It is quite a process. You know, I think, you know, from my perspective, it seemed, you know, of course, industry is going to have an outsized influence at the commission, which regulates, you know, industry. And the environmental groups are always going to be somewhat of a outside voice. But I sometimes felt like an outside voice. And I think, you know, sometimes the rules, I think, I don't want to denigrate the work that this commission did or the good faith efforts or all of the thousands of hours that everyone put into the rulemaking so far. It is burdensome. We have gotten some results. It's just that we need a lot more results on cumulative impacts in particular. And I just really can't reiterate enough that because decisions are being made today based on that data, the CIDR database, and I'm sure it's being worked on at this moment to prepare the February cumulative impacts report, you know, please, like, double check those numbers. Like, you know, maybe there is an explanation as to why, you know, 30 wells won't produce, 30 horizontally drilled and fracked wells won't produce any flowback emissions. Maybe I'm missing something. You know, y'all are the technical experts, but they just don't really seem to make sense. And, you know, I think it's a fair point that if one operator, if those numbers are all accurate, that means that some operators are managing to do the same types of activities with, you know, 100 times, 1,000 times less pollution. Like, how can we not make that standard across the industry? Like, so you know, I definitely think and hope that that those comments are heard today, if nothing else.
Thank
Is
you,
that-
Ms. Merlin. I appreciate that response, and I do very much appreciate your perspective. I would agree that the rulemakings are very robust, they're broad, they're difficult, they're, as the cliche goes, the making of sausage, and sometimes messy to produce a result that is the most effective, and that's the intent of rulemakings. And so I appreciate your counsel there and your work on this. I, Mr. Chair, also think that a lot more robust work needs to be done on this issue. As you've suggested, I certainly have more comments to make on that front, but I appreciate the petitioner here and the input and the spark, I guess, associated with this petition.
Thank you, Commissioner Ackerman. I want to sort of make sure we still have Ms. Merlin with us. I think she may be frozen.
I'm here. Can you hear me at least?
Yeah, we can hear you.
I'm definitely frozen. I'm kind of
Okay.
making a face, but yeah, I'm here.
Okay. And I want to correct the record. I was laughing with you.
Yeah, no, I took it back.
We've had a lot, we've had a work together quite a bit on all this, and I appreciate all the work that you've done on behalf of your groups. Any final questions for the panel? Okay, well, thank you for your presentation. With that, we will move into the deliberation sort of phase of today's hearing. I guess first, commissioners, we indicated to the public commenters that we would have an ability to ask questions of them. We only teed up Ms. Merlin for presentation. I have a sense of where this commissioner would like to go at a minimum, and that does not involve needing to listen to other folks at this time. I'm happy to lead if you're interested in that, but if other commissioners want to have questions for others, let's try to do that before I or someone else sort of leads out on where we may want to go.
Mr. Chair, I don't have any questions for anyone, and I would encourage you to lead us off here, since you're often not the first to go.
Okay. Well, good. So I read all of the 124 written comments. I read the petition. I went back and looked at what we did before. And as I mentioned to Ms. Merlin, I wanted to thank the petitioners for bringing this important matter to our attention. As is noted by most parties who provided written comment, we did always intend to come back to cumulative impacts with the second round of rulemaking. And I think that Wild Earth Guardians and the others have done a good job of reminding us of that fact, and that now is a good time to initiate that. But I'm not inclined to grant the specific petition for rulemaking before us. I am inclined to suggest that we do create a stakeholder working group, and I'll talk about that in a second, but I think it's important for folks to hear, at least from me, as to why to go that route as opposed to granting this petition. As I mentioned, while the issue of cumulative impacts and cumulative impact rulemaking is important, as I noted in my questions, granting this petition would serve essentially to make the petitioner's proposal as somewhat of a baseline proposal without the benefit of a stakeholder process. And I don't think that is the quote Colorado way. Granting the petition also could put the COGCC on a more expedited timeline and may not allow for the development of what I would call more sort of thoughtful draft rules that would be our baseline. We want to start a cumulative impact rulemaking with draft rules that have received the input and feedback from a variety of stakeholders on all issues, including some of the legal issues that were brought up by some of our commenters. Other state agencies are also working to address the issues raised in the petition, as noted by Commissioners McGowan and Commissioner Oath. AQCC, APDC, the Environmental Justice Task Force, regulation of air emissions from oil and gas is being looked at. and we need to work with all these agencies. And I want to see how their efforts progress to ensure the COGCC doesn't adopt rules that conflict with or create inconsistencies. That too, in my opinion, points toward a stakeholder working group over the first quarter or so of 2023. There also is the possibility of legislation resulting from the Environmental Justice Task Force recommendations that could significantly alter regulation. And we want to be able to analyze how legislative changes may affect COGCC's efforts to address cumulative impacts in DI communities. So I would propose we start a cumulative impacts review with an informational docket and stakeholder work group. We could open the informational docket and allow for parties to participate as noted. I suggest that we could get that started in, say, mid-January. Through stakeholder work group, all parties would be able to weigh in on the issues and provide perspective on cumulative impacts and work collectively on issue identification. I also would note that in a positive fashion that the petitioners can raise the issues from their petition as part of that process, but that this process would allow others equal opportunities to bring perspectives to the commission. This would be a commission-initiated work group, and then it would result in a commission-initiated rulemaking. And we would have an ability, say, through the spring of 2023, the commission can review the issues identified by the stakeholder working group, and it would be in a better position to then provide direction to itself and to staff and to the stakeholders of the initial direction that we believe is appropriate after having heard from everyone. This can be turned into a straw dog set of rules, and that can be the basis for a rulemaking at that time. This is not, in my suggestion, a delay stakeholder work group. It's a informative stakeholder work group. I would note that 181, and as you noted, Commissioner Messner, the APA and our rules require a stakeholder working group to include our sister agency, CDPHE, as a consulting agency when we consider cumulative impacts. And then finally, I would suggest, and I'm going to put him on the spot here, that we nominate Commissioner Ackerman as the lead commissioner to lead the working group on this matter. A couple of reasons there. He is the Environmental and Wildlife Commissioner, and that hat fits into this arena. Also, I think Commissioner Ackerman, who is relatively new to the commission and was not involved in the cumulative impact rulemaking that we did before, I like that kind of fresh perspective. And I think that Commissioner Ackerman, your background at CPW provides capacity and understanding about working group processes, which would be valuable to success. And then finally, I would recommend that we lean on Hearings Manager Larson as lead from staff. Obviously, this is up to the director, but be my thought that Hearings Manager Larson, who has done this in spades and really does a good job on working groups, would be great to serve as liaison with that. So those are sort of my thoughts. I would, if folks are in agreement, like to hear from everybody else, but ultimately, I think we would need a motion to approve or deny the petition and provide direction to staff and to the world at large that this is the direction we want to go in. So with all that said, I look forward to hearing from my fellow commissioners. Commissioner Messner.
Thank you, Mr. Chair, for leading us off there. I think your line of thinking is right in line with where I was going as I was reading all the different submittals that were provided as part of this docket. I think it was indicated by many of the parties that the commission during its mission change rulemaking hearings indicated that it will engage in additional rulemakings around cumulative impacts of oil and gas activities. I think we are at the time when we need to take the steps to do this. And by steps, I mean that we do follow the Rule 529D, which indicates that prior to the notice of proposed rulemaking, the commissioner director will establish a representative group of participants with an interest in the subject of the rulemaking pursuant to CRS 24-4-1032. I think this petition proposes rules that have not gone through this stakeholder process. So does not have the breadth nor the depth of necessary to be considered alone for the beginnings of a rulemaking process. From this commissioner's standpoint, the intent of the rulemaking process is to ensure robust discussion and input from a very diverse group of stakeholders, which will ultimately guide staff in developing a draft set of rules to be considered during a formal rulemaking process. Many parties have brought up elements that they would like to see considered in a rulemaking within this docket that have not been considered or contemplated by the rules proposed by the applicant. State agencies themselves are currently engaged in policy processes and rulemaking that will develop information critical to the consideration of draft rules by this commission and should be considered, and the agencies involved in the stakeholder process as contemplated by our rules. These agencies, should or could include CDPHE and its affiliates of APCD and AQCC, the Division of Water Resources, CPW, the Environmental Justice Task Force, as well as a number of others. COGCC itself needs to continue its work on developing and analyzing its cumulative impacts information that was developed through the mission change rulemaking, and to continue to understand baselines and net impacts, as I think those would inform the working group as well, or the stakeholder process. I think I'll call it rather than a working group. I think local governments need to be involved in the stakeholder process to ensure their voice is heard in the process. I think a broader swath of environmental and citizens groups from around the state need to have the ability to have their voices heard in the stakeholder process. And I think the regulated community needs to have a voice in the stakeholder process. I think the quality of rules developed by this commission is only as good as the stakeholder processes we engage in order to hear and absorb a broad range of information in the development of the draft rules. I think during the mission change rulemaking, we did take strong steps to both evaluate and address cumulative impacts of oil and gas activity. I think the development of processes to collect baseline information for future application of cumulative impacts analysis was an important step. I think the development and utilization of landscape level planning and analysis to understand and address cumulative impacts of oil and gas development was also an important step. I think the development of the out of service well plugging list was also a huge step towards addressing cumulative impacts, including prioritizing the removal of wells in DI communities. The reality is that thousands of wells and hundreds of current facilities are slated for being removed as a result of these efforts, and in many areas created a net decrease in overall adverse impacts. But with all of that, there is still more that can be done. And as some stakeholders have suggested, the first step is providing direction to staff is to initiate a broad stakeholder process to begin the necessary steps towards gaining the information necessary to begin drafting these potential cumulative impacts rules. So I would agree, Mr. Chair, that I'm a no vote on this current petition for rulemaking as it has been proposed for the reasons I stated above. But I would also encourage us to direct staff to develop and engage in the stakeholder process that is contemplated in Rule 529D, which in turn would inform a draft set of rules that this commission could contemplate in a rulemaking process at the conclusion of that stakeholder process.
Thank you for the comments. Commissioner Oath?
Yes, thank you, Mr. Chair. I guess as a non-voting member of this commission, but from CDPHE and having a large interest in these issues, and as I mentioned, a member of the EJ task force, wanted to just provide a number of comments as you're going into these discussions. One is, and I know that you all had a presentation from Joel Miner from our office on the recommendations, but just to put a finer point on that for all of you and others who may have missed that or aren't as intimately familiar with the task force recommendations as some of us are, we talked at length in the task force about how do we start to take, or how do we take the next step on cumulative impacts, right? And how do agencies approach that? Do we do this? Is it something that upon each application or upon each rulemaking hearing, an agency or the applicant does this analysis or this assessment of what are the cumulative impacts from this particular application? And then, so that was one approach that we discussed. And then another approach was maybe the right way to do look at cumulative impacts is kind of zoning pretty far out, right? And looking at them from a community standpoint and multimedia, because there are a lot of different ways that you can define cumulative impacts, right? Are you talking about multimedia things? Are you talking about air, water, food desert, health disparities? Are you talking about just air impacts over the course of time? Are you talking about cumulative impacts over a course of a geographic area, right? There's a lot of different ways to look at it. And so if you have agencies and or applicants doing this cumulative impact assessment or analysis upon each application or upon the consideration of each rule, you're going to have a lot of different approaches to how you look at that question, and then you'll have a lot of inconsistency. And so the task force ultimately came to consensus around that not being the right way to necessarily approach this, but rather a recommendation that, like I said, we do this kind of zone out and look at a sort of a broader community and look at what are all of the pollutant burdens that contribute to the experiences in that community, whether that be air, water, soil, et cetera, all of those things. And then once if the legislature agrees with that approach and does fund those, and when those analyses are done, then each of us in our agencies, because we have different types of decision-making that we make, right? You all make decisions around oil and gas development sites. We make decisions about air permitting and water permitting, but we also make decisions on grant making, right? The Department of Transportation makes very different types of decisions, and the Department of Agriculture makes very different types of decisions. So instead of prescribing exactly how agencies then should use those cumulative impact analyses, it would be on each of us to go through a process with our stakeholders and thinking specifically about what are the types of decisions that we as decision makers have to make, and how do we implement or apply that cumulative impact analysis in our decision making and in our processes. So I think as you guys are thinking about this, and I would agree that additional discussion to figure out how what additional rules you might want to do and how that fits with where these task force recommendations makes a ton of sense, given where we are. The other thing I would mention, Commissioner McGowan, mentioned that there are a number of efforts underway in other agencies, including ours, to address a number of the other issues that were raised. And so just to name a couple of things, really not a comprehensive list, but the Air Quality Control Commission has adopted a number of rules in the past couple of years that are really getting at a number of the concerns and that are really going to drive down emission reductions. So this is things like increasing leak detection and repair requirements, requiring more frequent testing for enclosed combustion devices within disproportionately impacted communities, as well as in our ozone non-attainment area. A number of different developments about phasing out and or inspecting and improving gas-driven pneumatic devices. We have a greenhouse gas intensity rule that's adopted and we're continuing to refine. And then in addition to sort of those kinds of actions, there's a whole other set of actions around gathering more and better information. So to the point in the conversation around, what do we know about the emissions that are reported in certain databases, right? So we are working on updating our inventories so they're more accurate. And so that's a big effort. We're doing aerial monitoring, in large part due to generous funding from this commission. And so we're working through that. We also have, again, through funding from the Martinez-Irwin funds, we have additional equipment, monitoring vans and equipment that are specifically dedicated solely to monitoring oil and gas facilities and emissions from that. So that we're getting a lot more information that can help also inform kind of what are the cumulative impacts from this industry in a number of different ways that I think will be very informative to your conversations. Thank you.
Thank you. I was turning my mute button. Did some commissioner raise their hand next? Commissioner Ackerman?
Thank you, Mr. Chair. I'd be happy to go next. If you'll permit me a little license, you mentioned that I have a background in wildlife, was with the state's wildlife agency and ultimately the Parks Agency for lots of years. And we would bump up against controversial topics on a relatively frequent basis. And one of the things that always struck me is that in Colorado, everybody loves wildlife, and we would talk about all of the different approaches that we had to taking care of wildlife in this state, but we're starting from a baseline of everybody loves wildlife. I believe that we have a similar baseline here. We're starting from a baseline of everybody, including this commission, the petitioners, industry, and all others do care about clean air, clean water, clean environment in Colorado. I think we're starting from a very similar place here. And, the details will help us kind of ferret out how we do that. Cumulative impacts monitoring as well as cumulative impacts rulemaking is a very, very important issue, and one that's important to me as a Coloradan, as well as many others. As I mentioned during my question to Ms. Merland, COGCC has done a lot of work since Senate Bill 181, and not just COGCC, but sister agencies, as well as DNR, as well as the citizens of the state of Colorado, as well as industry. And an amazing amount of effort has gone into the existing rules. That said, like I said in my comments, I believe that they can be better and will be better as we engage a diverse group of stakeholders from a grassroots perspective to start having this discussion that coalesces hopefully into a rulemaking. I wanted to point out, amidst these comments, sometimes it gets lost that we receive many, many comments, both the commission and others, that Colorado is the standard now, that people look to the state of Colorado for how to produce oil and gas in a way that's appropriate. And sometimes in the impassioned pleas, we get lost a little bit in the overall point of view. But does that mean that we can't improve? No, absolutely. Have we arrived? No, absolutely not. But I do want to make sure that we're looking at this in a proper context of Colorado is a state that cares about its environment and will continue to do so. And I expect a stakeholder process associated with cumulative impacts analysis to be no different. I expect it to be the standard, and I expect others to be watching what we're doing. I wanted to say to the petitioner and to the many others who commented, both individuals and groups, thank you so much for staying plugged into this very important issue. This is not an issue that has slipped off of the commission's radar. The commission has been gathering baseline data and continues to intend to engage in this issue and does appreciate the zeal with which others want to engage in this issue as well. I do concur with my fellow commissioners who have commented before that I don't think that while I understand why, from Ms. Merland's point of view, these rules were crafted, I don't think a unilateral writing of baseline rules as a starting point really is an appropriate way to start this conversation. I do think that a broader crafting of those rules is not just appropriate, but really is the next logical approach to our path forward here on an ultimate rulemaking associated with this. I did want to say thank you, Mr. Chair, for pointing at me to help lead this effort. If you'll permit me a little more license, you may be aware that the state of Colorado is in the middle of reintroducing wolves into this state. And I was part of that group as well. And I think the chair maybe felt a little bit of the lack of a controversial and important topic in my life as now that I've moved over to COGCC. So I appreciate you filling that gap in my existence. And I'd be happy to help lead and work with Ms. Larson and others to do so. We have a lot of smart people in this state. We have a lot of engaged people in this state, and that's one of the benefits. And again, I think one of the reasons that Colorado is pointed out as a leader, not just in this, but in many environmental topics. And so we fully expect to engage those smart people, and we fully expect to engage the public in helping us craft these rules in a way that continues to move our state forward in a positive fashion. And I don't mean to preempt, Mr. Chair, if it's appropriate, I'd like to at least put on the table a motion to deny the petition and to initiate a stakeholder group as you suggested. Happy to hold that motion for later as well.
Great. With regard to a friendly amendment that AG Davenport might suggest is to deny the petition for the reasons as articulated by the commissioners orally or something along those lines so that we've got that basis.
Thank you. I'm certainly amenable to that.
Did I get that right, AG Davenport?
Yes, that's fine, Chair. Thank you.
Yeah, okay. Commissioner McGowan.
Thank you, Mr. Chair. And as usual, fellow commissioners have addressed many of the things that I've been thinking about, and I think we're clear in the questions that I was asking earlier. I think the other thing that's missing from this request is any sort of assessment on the commission's ability to evaluate and address through the things that were asked for in the hearing. And I think that's going to be an important piece of the work group. And I'm obviously was concerned about inclusivity and making sure that other folks who might have some thoughts about our cumulative impacts process and reporting and how we're doing it weren't part of the request for the hearing and the what was asked for in the hearing. So I'm appreciative that we're open to looking at a broader stakeholder process that would allow for those things to get addressed and included. So with that, I would second Commissioner Ackerman's motion.
You're still on mute, Mr. Chair.
Oh, thank you. We have a motion and a second. Before we move into roll call, or does anybody have further thoughts they would like to share? Did you raise your hand, Commissioner Cross? Yep.
Thank you, Mr. Chair, and I will be very brief because I do concur with the statements of my fellow commissioners and the sentiment. I'll just say that I look forward to a thorough and deliberative process in moving forward with this discussion based on the work done by this working group, as well as with guidance from our sister agencies.
Thank you for that. Anything else? All right. We have a motion from Commissioner Ackerman and a second from Commissioner McGowan. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you. Would like to conclude the meeting with appreciation to the petitioners and their counsel, as well as to those folks that took time to provide written testimony to us. I think we've got a prudent path forward, and I look forward to hearing about the stakeholder work group, whatever you want to call it, as things develop. Commissioner Ackerman, thank you for taking or agreeing to take lead on that. You can report back to us at meetings as you feel appropriate, and we'll look forward to moving into a rulemaking following the evaluation of all things cumulative impacts, evaluating and addressing as a result of that work group. With that, I would look for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We're done for the week. Good work this week, commissioners, and good work to Colorado. We will see you next week.